Thank you to all 10 of you who are still here. You guys get the prize or the longevity prize, sticking it out. I'm always appreciative of the chance to come to the Olympus Risk Conference. You guys put on a great product, I think, for all of you, and I think this is a great opportunity to chat about different things. I pulled the short straw, though, intentionally by going last. You know, I know it's the end of the day. Everybody's got that post-lunch coma, now cookie coma. Though I know there's some caffeine back there. No, but, I was originally supposed to be in a week-long jury trial that was supposed to end today, representing the city of representing Park City on an automobile accident one of their officers was involved in. And at a pretrial conference just a few weeks ago, plaintiffs indicated that they wanted to postpone because they didn't want to. One of the things that's happening right now with jury trials is typically in a jury trial, voir dire or jury selection is done as the first day or half day of trial in the courtroom. And now they're doing that remotely. And that's the one portion of a jury trial that the courts are doing remotely. And so that was into our trial, and so plaintiffs wanted to push the trial. So this was a trial that was originally scheduled for a year ago. It was scheduled for this week, and it's now been bumped another 8 months to June. And so that is one of the issues that we're dealing with right now in litigation, is that getting to trial is no easy or small feat. I was actually in another scheduling conference just 2 weeks ago up in First District Court up in Brigham City, and the judge there said, "Hey, look, the reality of it is I have 50 jury trials that are waiting to go. And for my own sanity, I refuse to do more than one every other week." So you do the math. There's 2 years that you're going to wait to get to your jury trial, even though you could be ready tomorrow. So that's just the reality of it right now. Now, what I'm sure the different litigators who you talk to, they might say something different than me. You know, originally when COVID hit, I thought, hey, this could be really good. I think we now have a lot of leverage to get cases settled. But I saw the exact opposite result, at least for the first year, where people thought, you know, we'll stick this out and see what happens, and we'll wait, and not as many cases settled as I thought would, and they just keep getting rescheduled for later on, you know, kicking the can down the road. Whereas now I'm starting to see more of those cases that have been kicking around for a long time, where plaintiffs are finally saying, okay, you know what, enough's enough. Some money in my pocket's going to be better now than 2 years from now. So interesting dynamic, and, you know, we're just kind of rolling with it. What is interesting with litigation is that, you know, years ago, it seemed almost taboo to sue a city, to you know, if you were in an accident or differently, you got flooded, you know, that's changed. I don't think there is people don't have a second thought about it anymore, about suing a city versus suing an individual or business somewhere else. And I'm sure most of you are seeing this. But you know, the trend just continues to go up and up and up for cases that are being filed against public sector entities, and you know, of course, that's a taxpayer issue. But I think part of this is, you know, for a long time, public sector entities did not necessarily view issues or incidents or accidents with the eye towards, well, we're going to see that in litigation down the road. And I think now we're getting to a point where we need to start looking at things that way. Of course, it's easy for me to say I look at everything with an eye towards litigation because that's what I do. But the fact of the matter is, more and more incidents that happen are resulting in, ultimately resulting in litigation. Over the years, I've seen just about every type of case, and it seems like almost once a month, maybe more, I get one of those cases in the office where it's like, well, I haven't seen that one before, and now we have. You know, right now, or in the past, currently and in the past couple of years, we've seen claims for negligently, get this, negligently unlocking a police cruiser, which then an intoxicated bystander jumped in and drove off, got in a head-on collision and killed somebody. But the claim against the department was the officer negligently unlocked his cruiser. You know, we're seeing more and more, and this isn't going to slow down anytime soon, but we're seeing more and more claims for unlawful use of force or use of excessive force. One that we'll talk about here in a few minutes is a street sweeper that kicked up a dusty cloud, and a young lady then ran into the back of the street sweeper. She was injured, and the street sweeper, the machine was injured, but of course it was the street sweeper's fault because it happened to be in the middle of that dusty cloud. I'm being facetious there. It wasn't the street sweeper's fault. Failure to supervise after-school kids in a weight room, breach of a tow contract, failure to have a crossing guard in place when that crossing guard left just a few minutes early, failure to recognize a paid informant during a sting operation, slip and trip and fall cases. Those are happening, it seems like, almost daily. Uneven sidewalks, uncovered water meter holes in the street or sidewalk, failure to illuminate a street lamp, motorized scooter riders, wrongful death, and a taking claim involving, the claim is that $2 million worth of silk flowers were ruined when a water main burst. So, I'm going to talk about some things today that hopefully will help us kind of prepare for these issues and prepare to meet them, and so that we're not blindsided down the road. And hopefully, short little clip here. My hope also is that through proper preparation, none of you have a deposition like Michael Scott. So I don't know if you can hear that very well, but he said lying, and you know, for a litigation attorney, that I would be sitting there and just thinking, how in the world do I end this as quickly as possible? Those are the types of depositions you do not like to be in, at least when it's your client. Certainly when it's the opposing party, great. But let's talk about just a few kind of recent results. Is anybody here from Lehigh City? Do you know this case? The Jolly Lehigh versus Lehigh City case? Maybe, maybe not. You may not want to talk about it. I don't know anything about it, other than just kind of what we found online. Plaintiff was playing basketball at the City Athletic Center, fell through a glass window, and he was pushed by another player, and had lacerations that required surgical repair. He sued the city for installing glass, which was inappropriate for the activities that would be conducted on the premises. Is that a fair summary of the case? Maybe not. That's probably more taken towards the plaintiff. Did that case go to trial? No. Okay, but there was a settlement. For the information we had was $130,000. Let me give you just a little bit, a snippet, kind of a general rule to how we value cases, because I know that's one thing that's often like, where do you pull that number out? Typically, the way, and this is a very general rule, a very general rule is typically to value a case without any regard to liability, is you would say, okay, the person has, and I'm just going to pull an easy number out. You say the person has $10,000 for medical expenses. You would take that number and you times it by anywhere from 1, 2, or 3 to figure out what the general damages would be. Special damages are those quantifiable damages like the medical expenses. So you'd say, okay, $10,000 times 1. So, you know, it's general damages. We're gonna add another $10,000 to that for general damages. Total value of the case, $20,000. Again, that's a very general rule, and different things can drive that number up. The plaintiffs bar currently, they're working tirelessly to try and drive that range up. Many plaintiffs' attorneys would tell you that that number should be times 3 in every scenario. And, you know, there's certainly things that are going to drive that number up. So, for example, an automobile accident, where maybe the at-fault driver was intoxicated, that might be a case where you're going to times it by 3 or maybe even more. But that's just kind of general. So, you know, sometimes the thing about a settlement is, you know, cities, individuals, businesses settle for a lot of different reasons. Sometimes, you know, it's just that, hey, we don't need the publicity for this. Hey, we recognize we did something, that we have issues here, and we don't want this one to try. Sometimes it's just a risk reward way, trying to decide what could we be liable for down the road as opposed to what could we get this done for now. And so in many cases, it might just be a simple dollars and cents calculation. Another one that I pulled was, yes. Yes.
They chose to buy that glass, so they would then be immune.
Yeah.
So they would win the case.
Well,
So to me, I feel like liability is like paying a ransom for them. Yeah, we are supposed to pay a ransom because then everybody else is going to sue you.
we don't understand.
But I feel like, right? So you pay off these liabilities, so everyone thinks my buddy pushed me into some glass, so now I can sue the city because they kicked me out, even though I lost.
There's no question, it's circular, and it's escalating, it's just getting worse and worse and worse. Because, you know, and a lot of people, I mean, the previous sport knows that, and that's what they tell people is, they may think that they may know that they have the worst plan, but they think, well, hey, let's send them to demand and see what happens, or let's file a lawsuit and see what happens, we'll get some money. The street sweeper case, Stewart back to not on that because we went through the street sweeper case. It's no secret it wasn't a confidential settlement. We paid $8,000 on the street sweeper case. Part of that is, and we viewed that as, you know, nuisance value. Let's just get this done and over. We'd spend more than that going to trial. But see, you're right. That's the problem. It is insurance companies, cities, businesses look at the dollars and cents versus risk. What's it going to cost me now? What could it cost us later? Trying to decide what's our best option. Yeah, sometimes settlement is the best option because you don't want to create bad case law. You know, so a lot of cases, and I know Dave mentioned the UVSD case, the ballroom dancer case. That was actually my case. I was on the plaintiff side of that case with one of my partners. I'm the one who argued it to the Utah Supreme Court. Before going to the Utah Supreme Court, I called up the Attorney General's office and said, hey, look, I think this has a real good chance of creating bad case law for municipalities. You guys should settle this. Person we were dealing with at the AG's office said, you're young and dumb, you don't know what you're talking about, go away, we'll see you at the Supreme Court. We went to the Supreme Court and we won, and the Supreme Court clarified the public duty doctrine. I don't think it was all bad for cities and municipalities, and it probably just did myself a disservice by admitting to you guys that I was on the opposite side of it. But you know, that one was a very fact-intensive case, and in that case, the Supreme Court found that there was a special relationship between the instructor and the standard because of things that he had specifically been coaching her to do. But, you know, a lot of times there is a better opportunity to avoid bad case law by settling the case. And so there's a lot of things to look at. But you're absolutely right. Every time money gets paid to one of these plaintiffs, it just helps embolden the plaintiffs that, hey, you sue cities, you'll get money. And so, and that is one of the unfortunate things. I'm going to skip that one. There were actually, we kind of did just a verdict search regionally, and there were several interesting cases. There was one, the Satanic Temple versus the city of Scottsdale. So this is an Arizona case, not a Utah case. A member of the Satanic Temple sought to provide an invocation of the city council meeting. City council scheduled them a time and then replaced them with a Baptist pastor. The city council explained that they would rather the invocation be given by a representative of a religion with a substantial connection to the community. And then the plaintiff sought an injunction joining denial of non-Christian religious groups to give the invocation. There, the court found there was, gave a defense verdict. And, you know, there's a lot of, like I said, we're seeing more and more excessive force cases. There's a Gonzalez versus City of Tempe, again, an Arizona case. But that resulted in a $2 million, well, there was a judgment and then a settlement, which was a $2 million. The ultimate settlement, but it was one where a young boy was running away from officers about 100 feet away and was shot by an officer twice. Now, of course, you know, that one, I don't know all the specifics on that, why it was, why the $2 million. I don't know what their caps are. If they have caps in Arizona, I imagine they do. I don't know what they are, though. So yeah, let's talk just a little bit about this McEwen versus Clearfield City. So the street sweeper kicked up clouds, and on a summer morning, it was a beautiful, bright, clear summer morning. A 16-year-old girl saw the dust cloud from some distance away. She's on 1000 West. Up in Clearfield, and this is a street where, you know, if there are no cars in front of you, you can see a mile down the road. And she contradicted herself a fair bit. At first in the deposition, she said she could see way down the road, and she could see the dust cloud. And then later in her deposition, she said, well, the dust cloud suddenly appeared right in front of me. I said, well, then of course you saw what caused the dust cloud to suddenly appear, right? Well, no, I never saw the street sweeper. Okay, so it was too thick to see through, too thick to see around, over, under. So what do? Of course, you just barrel straight ahead, go straight into the cloud, and rear end the street sweeper. So let's talk a little bit about the street sweeper. The street sweeper had been going along the roadway. There was a section on this roadway that had no curb. It was like 3 houses long. And
I'm just going to move this closer.
Oh, sorry. I probably need to stand where I can.
I'm just going to move this closer to you so everybody online can hear.
Sorry for all you virtual people. I'll stand closer to the microphone. So he raised the brooms up for this section where there was no curb. and it was just dirt. He raised the brooms up, got past that section where the curve started again, dropped the brooms, turned on the water, started going. A dust cloud picked up. She drove into the back of the street sweeper. This is a view. This shows 1000 West. That straight road with the red dot is where the incident occurred. This right here is a picture of the roadway, street view picture of the roadway. You can see on the right hand side where those cars are. That's the section of road where there was no curb and where the broom was picked up. But so why was this an issue, and why am I talking about it now? The reason I'm talking about it now is, I mean, most everybody here is city attorney, risk manager, city manager, stuff like that. You guys usually aren't the people who are going right out when an accident happens or when something happens, right? A lot of times you don't hear about this stuff until after the fact. But one thing we need to be working on, again, having a focus towards litigation, is how can we prepare our city staffs or our other staff members to respond appropriately when something happens. You can't see the first bullet point out there. There were no pictures taken by city personnel of the street. There were no. There was a little bit of an inspection, but not a documented inspection of the sweeper. One of the issues that arose in the case was, well, was there water in the street sweeper? Was the water engaged when he had the brooms dropped? If so, why did it kick up so much dust? These are things that the plaintiff was trying to point out, saying you guys are at fault because you didn't properly use your street sweeper, or your street sweeper was defective. Now we had witnesses who could testify that, and our street sweeper, he did a great job in this deposition. I'm going to read you a few excerpts here in just a moment. He said, "Hey, look, when I drop the broom, the water engages." Now, the new street sweeper, which I just learned from Stewart a few minutes ago, was also just recently in another accident. But the new street sweeper automatically engages the water when the broom drops. The street sweeper at the time, the driver could not recall during his deposition if it engaged automatically or not, or if he had to push a separate button. But if we had documented that stuff on the day of the accident, it's a lot easier. It's a lot easier 3 years, 2 years, 1 year down the road because you have that information. Yes?
Stewart, how would this case change if we had a significant bodily injury? Let's say we had a permanent paralysis or something of this sort. Do you think you would have still been able to negotiate a settlement, or were you going to be headed for trial?
I don't think so. I mean, I can't speak for Stewart or the Clearfield City Council, but my guess is that if we wouldn't have put much more money on it, it was a liability case that we were willing to fight, or the city was willing to fight, and I'm always willing to fight, but the city was willing to fight this one, and so I don't know that. I think it would have actually made it more difficult to settle if there had been greater injuries, in part because of the clear fact that she drove straight in, her comparative fault. And so what's interesting here about this one as well is his mom was actually driving behind her daughter in a separate vehicle. Mom says she sees her daughter disappear into this dust cloud. So what does mom do? Well, of course, mom's worried about her daughter who's now in this dust cloud, and she can't see her, doesn't know where she went. So mom drives straight into the dust cloud as well, and narrowly avoids running into the back of her daughter. But we we didn't have written statements from those who went out to look at to inspect the street sweeper at the time. Again, no pictures or documentation of the street sweeper, or water levels, the buttons or controls inside the sweeper, things like that. Things like that could certainly have been helpful. We had pictures like this of the exterior of the sweeper, but you know, and public entities are getting better and better about this all the time. But you know, especially now where everybody has a camera with them pretty much all the time in the fall. But you know, pictures can do so much to help document something for 2, 3 years down the road when we're in depositions or when we're at trial. This was one, it was Jane versus X City, only because it was a confidential settlement, so I don't want to give too many details about it. It was a pretty ugly one. It was a claim for breach of contract, whistleblower claim, FMLA violation, deprivation of due process. And what's interesting, I mean, a lot of interesting claims in this one, but this is one in which, well, let me just read the summary. The employee was an employee of the police department, was fired after lying in a Garrity interview. Anybody here know what a Garrity interview is? So it does. So a Garrity interview is essentially, it's similar, it's probably one of the easiest ways to explain it to people who don't know, is it's similar to giving Miranda rights to an employee of a police department. Similar to, it's not the same as Miranda rights, but it's basically you give, put somebody under Garrity or give them a Garrity interview, and it protects them from having consequences brought against them later on for speaking truthfully to their superiors. So in most situations where you're going to see this is a police situation, where like an internal affairs investigation, something like that. So this employee, she was giving a Garrity interview and she lied. And there's this a disputation as to whether or not later on she admitted to lying to the police chief or not. Police chief said and documented that she did lie. She of course says no. He says that she did admit to him to lying. Of course, she later on says I never admitted. But so she was terminated for lying while under Garrity. A little backstory to this: this employee was on probation at the time for a different issue, totally separate, and that probation had included one day off without pay, and a suspension for 1 day without pay, and then a 1-year probationary period. Well, we sought to dismiss the case on the summary judgment motion, claiming that she was a probationary employee and the city could terminate her. She had the contractual right to her employment. She had no property interest in her employment because she was a probationary employee, and thus they could terminate her. The court said not so fast, because hold on, because let me just read this so I don't get it wrong. The disciplinary action included included suspension for 1 day without pay. Although the disciplinary letter outlined the right to appeal the disciplinary action and the process for doing so, the court found that because Utah Code 10-3-1106 only allows for appeals of termination or suspensions of 2 days or more without pay, she was denied due process and thus her probation was not valid. So the moral of the story is, if you're going to put somebody on probation, do it for at least 2 days, not just one. I mean, unfortunately, that's really the message, is that if you're going to do it consistent with Utah law so that they have their due process right. Even though she was told, you have the right to appeal this decision. She was told the process for doing so, the timeline for doing so. The court said, it doesn't matter. She didn't have a statutory right to appeal that decision, and thus her due process rights were violated. And obviously, if she'd been a probationary employee, the outcome's different. It was, and there wouldn't have been a settlement in that case if it was. That case was well documented. The police chief had this employee in for a formal interview after the report of her lying during the Garrity interview. He had his assistant chief and another lieutenant in that meeting when he discussed this with her. And then very well written out, documented termination letter after this interview. But the one problem was when we took the depositions, or when they took the depositions of the assistant chief and the lieutenant, specifically about the meeting, both of them said, yeah, I was there. I don't really remember what was discussed. And, so here are two primary witnesses who can support the police, their chief of police, and they couldn't remember what was discussed. So again, another example of if we can document things properly, even if we never have to use it later on, if we do have to use it, there will be a big benefit. Let's talk about the inherent risks in recreational activities. I know a little bit ago somebody else kind of mentioned this, asking if, I think during Dave's presentation, if you were talking about the inherent risks. So 78B-4-509, the inherent risks in recreational activities. This says that any danger, condition, or potential for personal injury or property damage that is an integral and natural part of participating in a recreational activity. And those activities include, and you can see there's a whole bunch of things listed there. Rodeos, paragliding, hang gliding, roller skating, fishing. What I want to talk about though is scooter riding. That was just recently added in the last year. So then we continue. So any danger, condition, potential for personal injury or property damage that's part of the recreation, part of participating in scooter riding on property owned, leased, or rented by the county or city, and intended for that specific, for the specific use in question. I think most of this makes a lot of sense until maybe you get to the bottom bullet point. We'll talk about that bottom bullet point. Let's see, I'm gonna wait on that one. So the, well, actually, let me continue. There is, and I should note with the inherent risks of recreational activities, that statute, it was recently amended to add scooter riding because of the share scooter issue. Now, this is mostly an issue for cities along the Wasatch Front, cities in Salt Lake County, Utah County, Davis and Weber County, and probably maybe even mostly so for Salt Lake County. But it's becoming an ever-increasing problem. And but so the if we also look at 41-6A-1115.1, this talks about scooter share programs. and gives local ordinances or local entities the ability to regulate the operation and use of scooter share programs, but also to regulate the use or operation of scooters in the city. And that can be, it does specifically, again, I'm sorry, I'm going to cut some of that off. It does specifically in paragraph 2 say that a local authority may regulate the operation of a motor assisted scooter within its jurisdiction. So again, why do I bring this up? It's becoming more of a problem. And actually, this is a case that I have right now. It's a fairly new case. It's the first wrongful death scooter case I've seen. An individual cruising along on a sidewalk on a motorized scooter, hit something, crashes, fell, hit the back of his head, bled out and died on the sidewalk. I don't know that we've seen many other scooter deaths yet, but you know, these scooters go 17 to 21 miles an hour. And so I think it's only a matter of time as we will see more and more and more of these types of cases. I mean, you can see the same thing even with bicycles and even skateboards, longboards. You know, my brother has a motorized longboard that'll go 28 miles an hour. And, you know, and it has a turbo function where it will knock you on your butt if you just gun it. You know, we have e-bikes that will pedal assist up to 28 miles an hour. You know, all these things are getting faster and faster and faster, and they're just kind of a ticking time bomb for more and more litigation. What's interesting in the case of the city, and I'm not going to get too many details because it is an ongoing case, but they have a city ordinance that expressly states that it is unlawful for any person to drive a self-propelled vehicle upon any sidewalk. So the question then is, well, does immunity apply? So if we go back to that immunity statute, here's one little interesting nuance of this. The bottom bullet point, intended for the specific use in question. Okay, so if the city says scooters aren't allowed, is the sidewalk intended for the specific use in question? You know, so we kind of start to get into some of these very gray areas where a city's trying to regulate and say, we got to take care of this problem. But then there's the state statute that maybe have some conflict there where the city could have maybe had immunity. I mean, this hasn't been tested yet, but if the city did not regulate the sidewalks, but even said, hey, you know what? Go ahead and use our sidewalks for motorized scooters, motorized skateboards, motorized bikes, but the speed limit is 15 miles an hour. Well, then could you say, yeah, our sidewalks are intended for that use? Because we've said use them, we've given you a speed limit. Yeah, so I only bring that up, not because I have any specific answers or clear answers, but to just make you aware that sometimes, you know, the city in this case was trying to do good. And what's interesting, this city specifically, they do regulate these scooter share programs. They don't allow them in their city. When they see a line or a bird or any of those scooters in their city, they call the company and say, hey, you've got a scooter in our city, come get it. And they have them removed. So they've done everything they can to regulate and to take care of that. Please.
Are the manufacturer and rights operator involved in that lawsuit?
No. Now, I should mention that what's interesting about that lawsuit is it's not a share scooter. It's a personally owned scooter, which is another interesting little nuance. So Let's talk about a few kind of different issues that we're seeing in different things. And actually, I'm going to come back to this one. Let me start here first with depositions. Depositions, I often tell people, and sometimes this scares clients when I tell them this, I often will tell clients, hey, look, you're not going to win this case necessarily in the deposition. We could lose it though. And so I mention that here because, we oftentimes, I work with cities, city attorneys, city managers, risk managers to figure out on different cases, hey, who should we have as our witness here? Or witnesses? Who do we want as a representative of the city if they ask for a city representative? Or who do we want to use as a non-retained expert to testify as an expert on behalf of the city? Things like that. And sometimes I think we have to look a little closer at deposition selection. I have seen cases, and I want to read you a couple excerpts. I brought with me the deposition transcript for the street sweeper. And the street sweeper, Stewart and I sat together prepping this street sweeper. He's a guy with very, very little education, if I remember right. Just by his initial appearance, I kind of thought, oh shoot, we're going to need to spend some time with this guy. And he ended up being one of the best witnesses I've seen. Whereas I've had city engineers and others, people with really good education who overthink it and sometimes do a terrible job as a witness. And so it's just something, it's something to be aware of. So let me just read you a brief sentence, some snippets of this street sweeper's transcript. Question. Okay, let me ask you this. From the time that you started in position level 1, so the time of the accident, was the street sweeper involved in my client's accident the only street sweeper in use by the city? Yes. Question. And then at some point after my client's accident, the city bought another street sweeper? Yes. Question. Did the city swap it out for a new one, or do they just now have 2? They just have 1. Question. Okay, so they bought a new one and got rid of the old one? Yes. Question. Okay, let me ask you about training with the city. When you first got hired on the level 1 position, did you receive any training from the city pertaining to the use of the street sweeper? Yes. Question. Can you just briefly describe what type of training you got? Answer. Just general knowledge of the street sweeper and then how to operate it, maintenance. Question. And was that training specific to you, or was that part of a larger class? A larger class. Question. Do you recall who else was in the training with you? I do not. Do you recall who gave the training? I do not. Approximately how long did the training run for? I don't know. Was it more than a couple of hours? No. So would this have been a one-day thing, less than like a couple hours maybe? Yes. Do you remember if you received any written materials in the training? I do not. So you might think, well, what's so great about that testimony? I love it when I coach a witness and tell a witness, hey, when they ask you a yes or no question, give them a yes or no answer. If you can answer the question in 5 words instead of 10, please opt for 5. Things like that are always big things for litigation attorneys, because A, this witness listened and he gave a very clean and very simple deposition. Follow-up depositions are not the time for us to prove our case. Depositions are time for the other party to get the information they want or need. And so we don't have to volunteer information. If they want to ask a follow-up question, that's their job and that's their right. If the attorney is a terrible questioner, which I don't know, this one had some good questions and some sloppy questions. But if they're a terrible questioner, that's not our problem, and that's not our fault. We answer the questions they give us, and that's all we have to do. If it's a yes or no question and they missed the golden follow-up question, that's on them, that's not on us. You know, witness selection, witness preparation is key, and that's something that I think is always critical to work on with the city attorney, city manager, department heads, things like that, to find that person that's going to be the right witness. But then also non-retained experts. And so non-retained experts, let me just briefly, an expert witness is somebody who, by education, training, experience, expertise, can offer their opinions in court. They can offer their opinions as to how or why something happened, or how it could have been done better, or why it was done right. Whereas normal witnesses can, so like this witness, he couldn't give his opinions. He could say what he saw, what he did, what he knew, what he remembered, his personal knowledge of. Whereas a 30B6 witness can give opinions. So for example, in a case involving the water system, let's say a city water system, what better non-retained expert than maybe the director or one of the engineers in the city's water department who can testify to that. Now, we may go out and retain another expert as well, but we want to rely on and use those resources that we have, because somebody within the entity is going to know a lot more about the system than somebody coming from outside. So that's depositions. Let me come back to admissions of liability. Admissions of liability can be an interesting animal. Admissions of liability are essentially, for example, to say, like if it's a car accident, and say a rear-end automobile accident, to say, you know what, we're going to go ahead and say, or admit, yes, we are responsible for the collision, that we had a duty to not run into the back of your car, and we breached that duty. However, we don't admit to or don't agree with that the accident caused the damages you're claiming, or that the damages are the amount that you're seeking. And so you essentially separate those two and try and make the case a little easier. In cases of clear liability, sometimes what that might do is it might mean that so like for example, well, let's just take the hypothetical automobile accident, rear-end accident, but our city employee is a terrible witness for whatever reason. We just don't think he would be a good witness. Maybe there's some stuff in his past that would give them a lot of stuff to dredge up and make him look bad in front of the jury, things like that. Easy to say, you know what, we're going to go ahead and admit liability so that doesn't even come into issue. And then we're going to focus on the damages part of the claim. Now, in the case of, I grabbed the wrong thing here. In the case of Negro School District, anybody here from Negro School District? Okay. They kind of tried to do this in a recent case. This was a case that came down, I think it just came out here recently. But it was back in July, July, the decision came down. But essentially what happened there is the claim against Nebo School District, this was a school bus that turned in front of somebody, and they T-boned the school bus and injured a bunch of the kids in the bus. And so they sued, the complaint against the school district was had a claim for respondeat superior, which means, hey, you as the school district, you're responsible for your employees. So you're responsible for this driver. And so respondeat superior basically says, if he is responsible, you're responsible for his action. but they also brought a claim for negligent employment. And so Nebo School District came in and they said, you know what, we're going to go ahead and admit liability as to respondeat superior. We agree, respondeat superior applies, and we're responsible for the actions of our driver. So let's move on and let's just get this done. And they said, well, not so fast. We had another claim for negligent employment. They said, no, same thing. You don't get respondeat superior and negligent employment. And they filed a motion with the court. The district court agreed with them and said, yeah, respondeat superior and negligent employment, they're the same thing. You can't have them both. If they've admitted one, they've admitted, then that claim's gone. Supreme Court came back and said, not so fast. District Court and Nebo School District, they're not the same thing. These are different claims. Respondeat superior says you're responsible for your employee's actions. Negligent employment says that you were negligent by employing this guy. Did you look at his background? Did you see what sort of driving record he had? Did you look at, these other things? You shouldn't have employed this guy. So not only are you responsible for his actions, but you're responsible for your actions in employing him. So, I only bring up the Nebo School District to show that admissions of liability can be helpful if they apply and if they really, take care of the liability aspects of the case. Offers of settlement. Rule 68 offers of settlement are another good tool, or can be a good tool. I think I've shared the Peterson versus West Jordan City case probably every time I've spoken at the RISC conference, but it's a great example. Peterson versus West Jordan City was a claim for excessive use of force against a police officer. And right out of the gate, within like 2 weeks of the complaint being filed, the city litigator filed a Rule 68 offer of settlement. It's a public document, it's not confidential, so I can share it. And he filed it for $250,000. So this is a guy who was running from a police officer. There were warrants out for his arrest. They were actively looking for this guy because he violated a protective order. But then he had also gone on social media saying that he intended to shoot police officers if or when they came looking for him. And Facebook posts and things like that. Those Facebook posts got screenshotted and sent to the police department saying, hey, just so you guys know this, if you're looking for this guy, he intends to shoot you when you find him. And so police officers knew this guy intended to shoot him, knew that he knew they were looking for him and things. So what happens, they find him in a dark alley, if there is such a thing in West Jordan City, but they find him in a dark alley behind a shopping area, and the guy starts to run. And as he's running, he's reaching in his waistband. Officer body cam shows him reaching in his waistband, lifting up his shirt, and the officer describes seeing flashes of metal as the guy's turning around looking at him while he's running. So the officer, knowing the social media post that this guy intended to shoot him, drew his weapon and started to fire at this guy. Well, so he hit the guy twice, both in the buttocks, and he filed suit against the city for excessive use of force. The city litigator filed the offer of settlement for $250,000. They did not respond to that, ultimately rejecting it. Well, so what does a offer of settlement do? Offers of settlement can be a great tool. A lot of time, if used properly, a lot of times offers of settlement really don't do a whole lot. But in this case, it did, because what an offer of settlement does is it says, if the plaintiff, so let's say this case, $250,000. So if they go to trial, at trial, he gets a verdict or a judgment of less than $250,000, then he's cut off from any interest from the date of that offer, and he has to pay the defense's costs through that, from the date of the offer through trial. So in this case, this was a case we did numerous depositions. And this was filed 2 weeks after the answer was filed. And really then ended up kind of hanging over plaintiff's counsel for the rest of litigation, because they knew there was this benchmark they had to hit, and it was hot. Now, one thing I will say, what can be really tough with offers of settlement is making them high enough, and this is hard. This is one of the toughest discussions I have with city attorneys and or city councils, is to say, hey, look, I know you think this case is only worth $50,000. And plaintiff thinks the case is worth $150,000. I think you ought to make the offer of settlement, for $50,000. Are you kidding me? We're not going to pay $50,000. There's no way we're going to pay $50,000. No way. Now, the hard thing is, if you make an offer of settlement for $5,000 on a case that has some legitimate injuries, and you have to look at, well, what is the chance they're going to recover something? What's the chance they're going to recover more than that number? And so it has to be a number that A, is high enough to put some pressure on them to accept. B, that's high enough that if they don't accept it and we go forward, it's a number that we can beat at trial so that we actually get the benefit of it. C, it has to be a number you can stomach paying if they turn around and say, okay, yeah, we'll accept your offer. And that right there is probably the hardest thing, because sometimes there are just numbers out there that you don't want to pay. You don't think the case is worth it, and you don't want to pay it. And frankly, in most of those cases, I don't blame you. But offers of settlement, again, it becomes my job, the attorney's job, to inform or educate the city council as to these offers of settlement and why they're beneficial, why they should maybe put a certain amount of money on there. But they have to be done at the right time in the right amount to really have any benefit. So I hope some of this was helpful. There's a lot of stuff. Unfortunately, there's no magic 8-ball as to avoiding litigation, predicting how litigation might turn out, or what the outcome might be, especially when you're dealing with juries. There's also, no magic 8-ball as to what a judge is going to do on motions. The fact is, most judges, at least in state court, they don't like granting motions for summary judgment. They don't like granting motions to dismiss. They'll do it sometimes, especially when you've got the Governmental Immunity Act and Public Duty Doctrine and you've got a clear case, that certainly helps. But if it's not a clear case, it's so much easier for the judge just to kick it down the road and say, yeah, you know what, I'm going to let this person go forward and have their day in court. And that's what's difficult. That's what's frustrating with litigation. But the more we can do early on, having an eye towards litigation, prepping or preparing or documenting an incident so that we can meet it head on when the time comes, is only going to help as we go down the road. Are there any questions that I can answer? Well, thank you for your time. It's been a pleasure being here.